Welcome back, you guys. We have the amazing Bonnie Yates who's joining us via Skype, and she is a special education attorney. Welcome to the show, Bonnie.
Thank you, Shannon. I'm a slightly discombobulated special education
You look
attorney.
fabulous. What are you talking about?
Trying to figure out how we're going to keep it all together in the
Yeah,
next 30
but
days.
we will. You know, I mean, here's the thing. What's the thing about necessity being the mother of invention?
That is the thing, Shannon. That is the thing.
We're gonna work this all out. We're gonna find ways that we never thought of before.
That's true.
And we're gonna keep on plugging. So.
That's all.
But it's, you know, I mean, I think everybody's sort of feeling it. It's like, uh-oh, you know, well, I didn't think about this, and uh-oh, I didn't think about that, right?
Yeah, I mean, but you know what? It's kind of maybe a paradoxical thought, but when this started happening, I was like, you know, we're all on the same boat in this life together. And this is a rare instance in which you see people coming together with the same goal.
Yep.
And I'm kind of sad that it has to come to this, but I do appreciate that it's collaborative, you know, and it's going to be each one of us extending our hand to somebody else, although probably only metaphorically.
Yeah, it's more going to be an elbow. We're going to extend an elbow to each other.
Exactly. So we're doing a weird loblolly show today of a variety of things, but I'm supposed to first tell you that when we do Autism Live, we're talking generally about your legal rights and how you can become empowered to better understand and participate in the process of your child's special education. But we also suggest if you have a specific problem, you really need to sit down with a licensed professional in your state and discuss what your issues are, because I'm just not able to give that kind of specific analysis on the air, you know, to any individual person.
Yeah.
So that's why we always refer people to COPA, Council of Parent Attorneys and Advocates, COPAA.net. You can go to their website. They've got a lot of information for you. You can join and become a member, or you can just use them as a directory to find an attorney in your state. And if we're in California, if you're in California, northern or southern, and you want to talk to us directly, we're Tollner Law Offices, and we certainly can offer you a consultation to discuss your special education issues. So I think that's what I'm supposed to say before I start talking about what we're going to talk about today.
That's exactly right. We love to get that information from you. Okay, so what are we talking about today, Bonnie?
Well, we're talking about whatever sort of tickled my fancy this week. So
I like it.
It's a lot of things. One thing is, I sent you, and perhaps you have not had an opportunity to post it yet, this redacted, oops, am I holding it down?
Yes.
This redacted prior written notice letter that will be available for the listeners to take a look at. I wanted you to see this because it's something that you can do at your IEP meeting, and I think it will alleviate some of your frustration. And districts certainly don't let you know that this is something they're obligated to do.
Okay.
But under the IDEA, if you're a parent and you ask the district to do something and they refuse, they are supposed to send you this document. It's called a prior written notice. And the prior written notice is supposed to explain to the parents what the issue was, you know, the request, what their decision is, and what documents and information they relied on in order to make their decision. And so a lot of times people are really frustrated because they feel as if they're, you know, steamrolled over or blown off at their IEP meetings. And in actuality, they have the right to get this prior written notice. That's what it's called. Those are the three magic words. It's sometimes abbreviated as a PWN. This one that I sent and that Shannon will be sharing later is a little different than some. And the reason it's different than some is it actually says yes to the parents rather than no to the parents. So I guess because they said yes, they didn't really give all their reasons or what they relied on. But I just pulled it out for form so you could all see it. So in the letter itself, what you see is that the student um, was in one district and had divorced parents and needed transportation to um, the parent who lived outside of the district or had moved outside of the district. And so the parent asked as part of their settlement if they could have transportation, out of district transportation on the days when the student stayed at the parent's house who was outside the district. And the district actually wrote back and said yes. And this is how they did it. So you'll see that there's a factual discussion, and then the district's telling you that it believes it appropriately complied with all applicable requirements regarding residency and permit issues. However, they've decided that they're going to do this. So, anytime you finish your IEP meeting and you feel like there are unresolved issues that you didn't get answers on, ask them for a prior written notice. Now, I know you're going to ask me, well, how long do they have to reply? And the answer is there's no set deadline. It's a reasonable time. So whatever is a reasonable time in light of the, circumstances. But you should hear something within 30 days. So that's the prior written notice issue. The next thing is about reading the law. Okay, reading the law. Every month, the Office of Administrative Hearings writes decisions that are about special ed, and they resolve disputes in their written opinion. And nobody can be very effective in special ed unless you know the law, and that means that attorneys like me need to try to make time to read these decisions every month. And when you do read them, they're really interesting because you really do get educated about what the issues are. Have to be an attorney to read these decisions and understand them? Absolutely not. Where do you look at these attorneys? Where do you look at these decisions? In California, you go to the California Special Education Hearing Office, and they have decisions online, and you can search by your district or by topic area. It's not the greatest search engine ever, but you can find stuff. And if you get interested, you can call OAH, the Office of Administrative Hearings in Sacramento, and get put on the email list, and you can get the monthly decisions. So I wanted to give you some examples of the kinds of things you can learn about in reading the law online, the OAH decisions. So just as an example, I was reading a decision last night, and one of the allegations in the case, it was a very complicated case. One of the allegations was that the student had been bullied in school. Why am I not? Shoot. Well, I'm having a problem with the document that I saved, so I'm gonna have to resort to giving you guys the bullying definition next week, which I will do. But I thought it would be interesting for you to know what I think it's Cal Education Code section 48900, and I'm gonna just see if I can find it really quickly now. The reason it was interesting to me to come upon this definition of bullying is because bullying is a pretty common topic of discussion now, particularly for parents of kids with disabilities. And so I thought it would be really important to actually look at what the law says and discuss it a little bit with you. So it is California Education Code section 48900, and this is just going to be the story of my day. Nothing is working. I'm going to have to do the bullying citation again next week because what's coming isn't what I wanted to share with you. So the other thing I wanted to share with you is we have federal decisions, and they are sometimes reported um, on the internet. So sometimes you can look at some of those kinds of decisions. They're different, but also this is a published decision. It doesn't look like anything. There's no point in holding it up. It's a published decision from November 2012, Upland Unified School District. And if you go into the decisions, the way they're written, if they're written logically, is first of all, they give you a summary of what the issues were and how the case was decided. Then they give you factual findings, and then they analyze the facts in relation to the law. And it's what happens is when you get into the discussion or the analysis, I should say, in the decision itself, the law that they discuss in the particular case has applicability to a general case. So I'm just going to read you a few things out of this Upland decision so you can see what I'm talking about, and you can let me know if it makes sense. Apparently, in this case, the parents were seeking reimbursement for private school tuition. And so one of the things the judge had to decide was whether they were entitled to tuition reimbursement. So she says, parents may be entitled to reimbursement for the cost of placement or services they have procured for their child when FAPE is at issue. Such reimbursement may be ordered when the school district has failed to provide a FAPE and the private placement or services were appropriate under the IDEA and replace services that the school district failed to provide. So there you go. Right now, you've got an explanation of what the standard is if you want private school tuition reimbursement. It's not only that you have to show that the private you have to show not only that the private placement was appropriate, which is demonstrated by showing that the student made progress over at least one quarter's worth of time, but you also have to show that the district's prior placement was inappropriate. So you can't just, apply to private school and get in, and if it's a great school and you do well, that's not going to work unless you can show that the district's offer didn't provide FAPE. So the decision goes on to say, school authorities may also be ordered to reimburse parents for their expenditures on private special education for a child if the school authorities did not offer the child a FAPE and the unilateral placement chosen by parents is appropriate under the IDEA. However, and this is interesting, the placement chosen by the parents need not meet the requirements for a FAPE as long as it offers an appropriate educational program. So what they're saying is you're not going to be held to the letter of the law. There's not going to be an analysis as to whether the private placement offered FAPE, but it is going to be looked at for appropriateness. The determination regarding such reimbursements is based on general principles of equity, which just means fairness. And they cite the Forest Grove School District case, which is a Supreme Court case and is an important case because it looked at this issue. The highest court of the land looked at this issue. Such principles can include a variety of factors, including the failure of the parents to give adequate notice of their intent to enroll the child in private school and the parents' reasons for enrolling the student in private school in the first place. So that's interesting because what it's telling you right there, and I think I've told everybody this before, when you're going to pay for private services or private placement, you have to give the district 10 business days notice of your intention to privately place, or you have to go to an IEP meeting and give the notice right there. And the purpose of the notice is to give the district time to make you another offer if they want to, and to prevent your exit from private school. Goes on to say, the idea also places several statutory limitations on reimbursement to parents for costs of a placement that they have selected when FAPE is at issue and the school district has not offered FAPE. Specifically, 34 Code of Federal Regulations, Part 300.148 provides that the amount of such reimbursements may be reduced or denied under certain circumstances, including 1, if the parents did not give notice at the most recent IEP team meeting, that the parents attended prior to removal of the child from the public school, or at least 10 business days before removing the child from the public school, that they were rejecting the placement, including stating their concerns and their intent to enroll their child in a private school at public expense, or 2, if the actions taken by parents were unreasonable. So there you have, in real life, rolling out in this Upland School District case, a cogent discussion of the rules as they relate to unilateral placement of children in private schools. They had some other issues in this case, and the judge ruled on those things. For example, the parents apparently asked for some kind of extension on the statute of limitations, which in California is 2 years. And there are some exceptions that apply, like the school district engaged in fraud or convinced the parents that the problem that the parents had was resolved. So the judge goes on to say, a request for due process hearing shall be filed within 2 years from the date the party initiating the request knew or had reason to know of the facts underlying the basis for the request. And then the judge cites the applicable education code section. This limitation does not apply to a parent if the parent was prevented from requesting the due process hearing due to either 1, specific misrepresentations by the local educational agency that it had solved the problem forming the basis of the due process hearing request, or 2, the withholding of information by the local educational agency from the parent that was required to be provided to the parent under special education law. So that would mean if at the time that the district engaged with the parent, they didn't provide the parent with their procedural safeguards. So the judge, I'm not going to discuss the whole statute of limitations discussion because it's a bit technical, but I wanted to show you how the law is interwoven through this specific decision. Then the judge went on to look at particular school years and to look at the question of whether the district's failure to assess the student and develop an IEP meant that the district had denied FAPE. And these decisions tend to be long. They're very lengthy. You can learn a lot by reading them if you can just, take time, maybe like one night a month or something, to just read a few of these before you go to bed. This one's about 25 pages. Sometimes they're longer, but that's information that's all available to you as parents, and it's really not something that you should be intimidated by. Because I think you can read this and you might not understand everything, but you'd be amazed. You'll start to catch on, and you can look up definitions in just Google generally if you don't understand what a term is. So I think that this would be a great idea that you guys can all start reading the law a little bit to yourself. And just know that an attorney doesn't do anything different than that. We have legal training, and that helps us, of course, interpret this. But these decisions are supposed to be written so parents can understand them by the administrative law judge. So check them out and see whether you find that they're interesting and helpful. I've also given Shannon the Special Education Rights and Responsibilities Handbook, SERR, for California. It's put out by Protection and Advocacy. It's free. It's an incredibly thorough book. It will help you so much if you just go in there and you read the law and go through the ideas sequentially, starting with the beginning, which is probably eligibility. So that's another thing I want to remind you about as you roll into IEP season. So that's what I wanted to say on that topic, Shannon. I don't know if you have any comments or questions before I start about the next.
I just want to say that the links where we have links and the documents where we have documents are all in the comments on Facebook. So if you're tuning in and you want to know where those are, go over to Facebook. If you're not already there, go to Autism-Live and find where we're streaming this live or where it's recorded, because it lives there on Facebook, and you'll see that it's in the comments all the things that Bonnie is talking about. Traven is putting them there for you. So,
Okay, great.
okay. So what next?
Okay, so I'm still like obsessing about the fact that I couldn't pull up my bullying definition, but
Well,
we're not
we'll have
going to
it
do
for
that.
next time. It's a wonderful tease for next.
Yeah, and I said I was going to talk about not Rowley, Andrew F. today, but I just was so busy this week that I just didn't get to it. So what I was going to talk to you guys about, and this might take more than one session, is age 3 to 5 services under California Education Code 56001. So do we have time to do a little bit of that?
We do have a time to do a little bit of that because that has been a conversation that I've been having with a lot of people lately, especially in the state of California. Bonnie, I have to tell you that we're seeing 3-year-olds with a diagnosis of autism being refused for educational services because they're saying they don't qualify.
You know, I'd be really interested in what district that was, because I knew of I have a colleague who was working in an office in LAUSD where the psychologists there were saying to her, you know what, we're not going to make these kids eligible. It's too much work. Let the school deal with it. And I was really shocked by that.
It's in fact, we're hearing it overwhelmingly in LA Unified. So,
okay, so it's LA Unified problem, and I think it's important to keep track of that, because you know, their LAUSD's IEPs are so general and so form-driven that they're almost meaningless. But, you know, you got to really look carefully at those assessments. She also told me, and this was equally shocking, that if parents were doing the parent portion of the evaluation, they would write the results of the parent answers in pencil, and then if they got a result they didn't like, they would erase the pencil later and write in something they liked better. And this colleague of mine was really shocked, and she was like, you guys are breaking the law. Like, you know, this is not just erasing a few pencil marks or something.
That is not okay.
LAUSD also seems to be right now trying to remove kids that have full-time ABA programs funded by the district from those services. And it's an interesting development because for years, LAUSD was one district where reliably, if you went to mediation, you could get an outside ABA provider through the mediation process. So I think now what's happened is, you know, somebody in the district somewhere is saying, well, this is a huge money suck out of the district. Let's start trying to take these cases back. And the problem is it's not that easy for them, because what they have to do is they have to go in and show either that the student doesn't need as many services, which would be a more conservative way to go. But I'm hearing that what they're doing instead, maybe for simplicity's sake on their end, is they're actually trying to make students ineligible. And to do that, they have to show that their autism, they either don't have autism, which is going to be a little hard to do, or that their autism has no educational impact. That's kind of mind-blowing.
Well, it is. For people who are supposed to be in the field of education, that is such a long walk off the beaten path to say that a 3-year-old, that autism is not affecting their ability to be educated. It's just that it's mind-blowing to me. But okay, so but we wanted to talk about the 3 to 5. Yeah.
3 to 5 is interesting, right? Because you're transitioning from being an infant or a toddler to receiving IDEA services. There's a separate conversation about 0 to 3 services in California and how the regional center does that. Probably would have made sense to do that first, but this seems more pressing for people in a way.
Yeah.
So in California, there is this issue of transition, right, from early start services to what are called Part B services under the IDEA. So California Education Code 56426.9A requires a smooth transition from early start services to 3 to 5 services. And the IEP has to be in place by the student's 3rd birthday. If the child is turning 3 in the summer, Regional Center may have to continue services until school begins. and that's 17 California Code of Regulations 52112 paren F. Eligibility for special education, all the eligibility categories, including autism, you can look at 5 California Code of Regulations 3030, and you'll see that 3 to 5 has all the same eligibility codes, except for there's an additional one called established medical disability. And the definition of EMD is it's a disability, it's a disabling medical condition or congenital syndrome that the IEP determines has a high probability of requiring special education services. So you could see that there's an attempt there to make sure that you're over-inclusive, which is a good thing, because the worst thing that'll happen is that if somebody doesn't need that level of services or doesn't need to be eligible, that, that could be changed ultimately. But anyway, for the EMD category, they must also need specially designed instruction or services to qualify for special education. There you have them saying essentially if the needs can be met in a general ed setting, they don't qualify. Also, a child must have needs that cannot be met by modifying the home or school or both without ongoing monitoring or support. And eligibility is not going to be granted if it's the problem is lack of familiarity with the English language, temporary physical disabilities, social maladjustment, environmental, cultural, or ergonomic factors. So you can see those are things that might look like a disabling and eligible condition, but they're actually not. California Education Code 56441.11c. Assessment should be comprehensive, and it should be more than just speech and language evaluation. So they're supposed to do a multidisciplinary assessment when you're turning 3. They're not supposed to do a bare bones assessment. As far as the transition from early start, 6 months before the 3rd birthday, the Regional Center Service Coordinator must A, notify the parents regarding the transition meeting and the need for transition planning, must notify the school district the IFSP meeting, and then they need to discuss placement and procedures for change in service delivery providers. Because, as you've seen if you're in California, under 3, with the impetus being to try to remediate the disability as early as possible, there are services that are not always available over 3. And even if you're going to have the same services over 3, you're not going to have the same service providers, right? Because you're switching from regional center and its vendors to school district and its programs. So there's a requirement that the district be careful. The regional center has to transmit the information to the school district, so I should say the regional center should be careful to make sure that the district gets all the information that it needs and that the parents are appropriately prepared for this transition, which can be a big one. California law requires that parents are provided information, recommendations, and resources. Information about the child is sent to the school district and regional center to determine what assessments are necessary. A projected date for conducting the final review of the IFSP, and ensure that steps are taken so that the IEP is in place by the 3rd birthday. The referral to the school district must occur no later than 2 years, 9 months of age. People responsible for convening the IEP and the final IFSP meeting need to be identified. Parents should know timelines to avoid gaps in service. That's important. There is no stay put of early start services if you disagree with the IEP. 34 CFR 300.518C and California Education Code Section 56505D say you can consent to the implementation of the IEP and file for due process, but you don't get to keep your 3 to 5 services. 3 to 5 rights are the same rights as 5 to 22nd birthday rights, meaning 3 and 3 to 5-year-olds don't have fewer rights than people that are 5 to 22, which makes sense. Services may include, for the 3 to 5 population, observation and monitoring of the child, activities developed to conform with the child's IEP and to enhance the child's development, consultation with preschool family service providers and so on, preschool, family, service providers and so on, assistance to parents in coordinating services, opportunities for the child to develop play and pre-academic skills and self-esteem, access to developmentally appropriate equipment and specialized materials, and that's California Education Code 56441.3A. Related services can include parent counseling and training. Services can be individual or group and can be provided in age-appropriate environments, including home. Isn't that interesting?
Yes.
The IEP must meet the child's unique needs. That's 56441.3 of the Ed Code. The settings can include a private school, a child development center, family daycare, your home, preschool, or a public educational setting, as long as the setting provides an age-appropriate environment, materials, and services. And the district is allowed to contract with Head Start if they don't have their own preschool program. LRE, least restrictive environment, applies to the 3 to 5-year-old population. That's 34 Code of Federal Regulations 300.116. The district must provide a program with non-disabled peers if the child's IEP team determines that this is appropriate. However, the district is not required to offer preschool if it doesn't have one for children without disabilities. There's no federal requirement to establish district-wide programs or contract with private schools for the sole purpose of implementing LRE requirements. Courts have not made a distinction between school age and preschool age when addressing LRE requirements. So that's alluding to a problem that sometimes comes up where the district doesn't have an appropriate preschool and what their duties are to provide an appropriate preschool in those circumstances. And I'm not going to go into the law on that today. It's a little bit complicated.
And we are at the end of our time. Is that a good place for us to stop, Bonnie?
That is the end, yes.
Okay, fabulous. Can you please give us, the Tollner Law Office information again, please?
Tollner Law Offices, you can Google them if you want to get a hold of them. The phone number and the intake form is right there on the web. And we didn't get any questions this week. Love to hear from you guys next week. If there's specific topics you want me to talk about, bring it on, and everybody stay safe and healthy.
Absolutely, and to you as well. And thank you for taking the time to be with us and share this information, Bonnie.
All right, enjoy the rain.
You too, bye-bye.
Bye.
Hey, thanks for watching Autism Live. To subscribe, click here. And if you'd like to check out some more of our videos, click here.